Hello?
Hi, it's Kraut Law Group. You called us a little bit earlier.
Hi, thank you for the call back.
No problem. So what's going on?
Give me one moment, please. One sec. What do you have with you? Did you get my message, or do you only have my contact information?
No, I got your message. I heard what you said. I'm just trying to get a little context to it. So you are, I assume your case, when did you have your preliminary hearing?
The preliminary hearing was scheduled on, let me tell you. It was a March 20th.
Okay, so over a year ago.
Yeah.
Okay, and what court is this out of?
Well, the preliminary hearing was held at, but the proceedings have since migrated to, yeah,
Do you know which department?
department.
Okay, and who's representing you?
It is a gentleman by the name of,
Yeah, we know that person. Okay.
do you mean that in a good way?
No, not necessarily.
Well, yeah, he doesn't, he's not very responsive or diligent.
There you go. Yeah, that's it. So he's had you this whole time?
Since,
And,
I'm sorry, go ahead.
sorry, no, go ahead.
Well, I had private counsel on it, and they basically they didn't do anything. They sat through the probable cause hearing, and they didn't do anything. And so when I asked them to file the Section 995 motion as a remedy to the...
Quick, who is your private counsel for prelim? Okay. Yeah. And so when you say they didn't do anything, what do you mean they weren't?
Well, he sat through the preliminary hearing, didn't raise one single objection.
Okay.
The many different kinds of objections that I went through the preliminary hearing and could find, he didn't raise a single one. And when it came time for the affirmative defense, the judge asked if we have an affirmative defense. We clearly prepared one. We had one, and he denied. He said no. And when it came time to just basically present the motion for dismissal, he didn't have a motion ready. He gave a seated and oral just kind of request. He made an oral request seated at that, really impromptu, and said that it needs to be reduced to a misdemeanor. But that's not what we had talked about. We talked about how there isn't probable cause to move to trial on this one or any prosecution. So, but he very dismissive and says that my argument is a trial argument when in fact it's not. So anyway, the private counsel that didn't get the work done at the probable cause hearing, I have relieved him of his position and moved to bar panel, and that's when Mr. came in, and Mr. Didn't respond to me, so then I removed him. I did a ton of research. I went pro per, and we had a 995 hearing, which I wanted the attorneys to be present, but the hearing didn't start. The judge denied the 995 motion, and then basically I didn't have a hearing on that motion. So then I brought it back to, roughly speaking, I tagged in Mr. again, and he has been on the case, and he just doesn't respond to me.
So I guess I'm not. You filed a 995, correct?
Yes.
And the judge said the judge didn't hear it.
So as far as I know, and this is what, and I've contacted Mr. a previous, the private counsel, the original counsel, and he was kind enough to let me know that it's only presumed that the judge has read the motion. He doesn't have to read it technically, and he doesn't need to prove that he's read it at the hearing. So that's where it was. He I guess, for roughly speaking, he pretended to have read the motion, and all he did was just deny the motion. That was the hearing. He just.
So it's been, the 995 was denied.
We didn't have a hearing on it. He just denied it. The day came for the hearing. I'm sorry?
Right. So the 995 was denied. I'm just procedurally trying to get a...
Procedurally, it was denied, but substantially nothing happened.
Okay. So 995 denied, and where are you... are you set this for trial?
No, it's a pre-trial. It needs to be dismissed at pre-trial, and my plan is to file a motion for reconsideration, the civil motion, and then get the 995 determination reconsidered because he hadn't even read my motion.
Okay.
That's where we're at. I'm certain that this can be dismissed with the 995 because there is a ton of case law and doctrine that basically doesn't allow anybody to make these allegations against anybody unless they have admissible evidence of criminal intent. And I say admissible evidence, it's a bit technical. There's no evidence of criminal intent. In this case, it's me and this random guy, we're just joking around, and then they take the joke out of context and they charge it as having all of the elements present. And one of the elements would be that somebody has made a threat with the intent for their statement to be taken as a threat, i.e. they meant to scare somebody. But that's just not true. There's no evidence of that, and they're alleging it, but you can't allege anything based on an inference. So, it's the core element is missing, and we need it denied. We need their their charge to be dropped. It's not on probable cause. They don't have solid basis for this.
What do you do for work?
I'm currently not working because I deal with this. I'm doing the research for this stuff.
Well, yeah.
But if you're asking if I can afford your service, I certainly can.
Okay, that's I'm very upfront with you. I'm telling you, if the 995 was filed and then denied, I'm not seeing what the grounds would be to refile it.
It's a motion for reconsideration.
What are the changed circumstances?
The changed circumstances that we didn't have a hearing. There is due process, and he didn't respect due process. The process is to have a hearing and go back on the preliminary hearing record. When somebody files a 995, as a judge, you're supposed to go back on for the hearing. You have a hearing on it, look at the merits of their motion, and then do another legal analysis of the merit for the bind-over decision that the magistrate made. But they didn't do it. We didn't have a hearing. So
what happened that day?
He just denied it.
Okay. Were you given an opportunity to argue the motion?
No, the judge brought up their own argument sua sponte and denied it.
So you were not allowed to say anything?
The
argument of your motion?
No. No, everything was in the motion, and I filed a reply to the motion, to the opposition, and I wasn't allowed to argue for any of that. That's all been recorded, too.
Yeah, I know. Of course. So you weren't... You said, I want a chance to argue my motion. He said no?
Yeah, he brought up an argument that I never made in my motion or my reply, and then he just denied it in the middle of my argument. I'm literally, talking about what's in my motion and what's in my reply. I haven't had a chance to get 10 words out, and he just grabs the stamp with two hands and he stamps deny. I mean, it wasn't a fair hearing. It needs to be fair. We need to go based on all of the arguments and points of authorities.
And when was that?
This,
When did that happen?
the denial?
Yes.
Well, I filed the reply on the So presumably within 30 days of that date.
I'm sorry, when was the court date where you denied the motion, where you said you just stamped it?
Well, I don't have it in front of me, but like I said, if I filed that
If you're
reply...
going by your memory, was that the last time you were in court?
No, the last time we were in court was for a continuance Mr. made.
Okay.
It would have been in...
Just get an idea of that. Okay. And what's the statement that you're accused of making?
Well, the statement is, it's satirical, it's idiomatic.
What was the statement?
Well, I'm getting to it. It's an idiomatic...
I'm a real straightforward person. If I ask what color this guy's, just say blue. I don't need the build up to it. I don't need the defense on it. I get what you're saying. I also heard your message. What was the statement? If you give with quotations, what was the statement? I don't know what we're dealing with.
Well, because you'll take it out of context. I'm trying to give you context.
I don't need the context. I want to hear the statement.
Well, the law...
I understand all your other arguments. What was the statement?
Okay, hang on. Don't get snippy. I'll bring it up.
I'm a direct person.
I love it, but let me bring it up. I love it, but let me bring it up. I don't remember off the top of my head. Let me bring it up. I love it. Hang on 1 second. So verbatim, it's, do you have a mental illness or something? Question mark. What game? Question mark. Why do you want to play around all day? Question mark. I said, just answer my question before I come bash your skull in. And then he left a haha iMessage reaction on that message.
And who is this person?
He is a detective policeman for the police department.
Which detective?
This would be, I don't know if he changed his name or if it's supposedly detective.
Okay. I know him. The name's familiar. And
Okay.
why were you communicating with him? What was this?
So I had initially been looking through, again, if you want to know if the sky's blue, I just wanted to know if this person was who I thought it was. I had a phone number, but I didn't know if the phone number was accurate because the data that I have may not be accurate. So I double checked and I messaged the phone number if this is who I think it is. And he didn't answer the question. He said, "Who is this?" So then all I did was tell him to answer my question, but then he responded, instigating some banter. He sanctioned some banter and said, "We can play this game all day, what's up?" Why I messaged him was simply to find out if my phone number was correct. But because he initiated this banter, he sanctioned this banter, we kind of took a detour. I broke the ice with him with a bit of some absurd humor, and he laughed at it. And so now, I think that he's like a troll, and he likes this kind of humor. And so we continue on that in that theme. But I don't know him. He doesn't know me. And there is no history between us. There's no gravity of purpose, which is one of the elements, if you're familiar with Penal Code 422. They can't allege what they've alleged. When you look at it based on how it's supposed to be looked at, you can't allege this. You can't allege it willy-nilly. This is a very serious statute.
I understand it's a strike. I'm very familiar with it.
Yeah.
How did you get his number? Why did you start texting him in the first place? I'm not following that.
So, well, for one, I feel that I'm allowed to message anybody I want unless they tell me not to message them. So that's why I messaged him. But the reason beyond that was that I was trying to find out if he was the person I thought he was. I had gone through a list on a website, and there was a list of people and some names. I thought he was associated with my next door neighbor. And so I thought they were friendly because we're friendly with the neighbor. I thought they were friendly and associated with them. So then I messaged them trying to have a bit of a conversation with them. I was going to ask them a question regarding something with it's an unrelated issue, but I was going to ask them a question. And that's why I had messaged them. I didn't message them to threaten them. And I didn't ever threaten them, but they alleged that I threatened somebody, but I never threatened anybody.
Okay, well, just thinking.
So where we're at with this is that we're basically saying that there's no probable cause. You can't infer evidence. You can't infer evidence. There needs to be actual evidence. You can't infer it when it's not there. And so because a few elements are missing, they're inferring it. And that's just not allowed. We have case law that says you're not allowed to do that. We have doctrine that says you're not allowed to make this allegation. So I don't know how they're pushing it forward. They're just heavy-handed, or maybe they're not dragging their knuckles. I don't know what's going on.
Look, sir, play devil's advocate. If in any case of a threat, anyone accused of it would just say, "Oh, it's a joke," and you can't prove it wasn't.
No, because, well, hang on. Can I rebut?
Sure.
Because if you ask somebody, but there are many elements to what can be, as a matter of law, a threat. What, as a matter of personal belief, what a threat is not a matter of law. We go to a court of law. So there are many elements to it. If you're trying to charge somebody, and if you're trying to actually know what the heck is going on, one of the elements is intent. So that's why there's a colloquial, there's this phrase of, is that a threat? Or what do you mean by that? Or are you kidding? There are these things, these questions we can ask to sort of, to verify. It's not based on how we feel. It's based on what the speaker's intent is. And like we have doctrine. Yeah. So yes, as a matter of law, I don't think they have a case, and case law tells us that. But as a matter of personal belief, sure, yeah, you might think I threatened you. That makes sense. But did I threaten you? That's not, and that's my defense here. So I see what you're saying. I know what you're saying. But I want this to go how it's meant to go, not how they think it should go. Because what they're thinking has nothing to do with the law. They're inferring evidence that doesn't exist. So if they did have intent, and how could they have intent to, negate the whole, oh, I'm joking thing? He's like, well, no, actually 3 years back, you messaged the guy something similar, or maybe a few weeks ago you met him at Six Flags and you kind of, you shook your fist at him, and, then they can infer something. But that's because they have evidence. But they have literally, it's just, there's no threat here, so they can't do what they're doing, is what my defense is. That's what my argument is. It's not like I'm just pulling it out of thin air to say that I was joking. The whole reality is that I literally sent this man a joke, and so my intent was to entertain him, not to scare him. So they can't allege that I meant to scare him. That's one of the facts that they're alleging. And it's just a baseless allegation because it's not based on any evidence. If they had evidence of prior altercation, maybe, I don't know, maybe even if I had a prior record of any sort of violence, then they would be able to allege this based on that too. And it would be, based on evidence. But they have zero evidence to make this allegation. It's just not, they're not allowed to push the probable cause determination when there is no, factually, there's no probable cause here. It's not sufficient. So that's and I don't mean to sound like a know-it-all, but I've just done this one statute.
I understand. I understand your position on the case and how you're viewing it. And I gotta tell you, there are good lawyers and they're great lawyers and good clients, and sometimes the two don't match. And I just don't know if we'd be the ones for you, because I got to be very honest with you. What you, like your other attorney said, those are trial arguments. That's not a probable cause. You're not going to get any.
There are arguments that can be made at trial and at pre-trial, right?
But this is not a probable cause argument. You're not going to get any traction, as you see. You haven't. That's not going to change.
Why are you telling me that it's not a probable cause argument? Because there are arguments you can make at pre-trial and at trial. So there are some arguments that are both for trial and pre-trial, and this is pre-trial.
The argument would be my intent wasn't there, and that's going to be the jury. There's evidence that it was, just the text itself. So
well, that's not evidence. We have case law. Well, this
at the very, very, very low standard for prelim. Not a problem.
And case law says that low standard.
By the way, you can disagree with my opinion on that. That's absolutely true, but it's
I know.
not going to change my opinion.
Well, I think that I can persuade you, because there might be some things you're not considering.
I promise you would not be able to.
Well, you don't need to be so stern about it.
To persuade you.
You can persuade me. I'm letting you persuade me. If you can go against statute, if you can go against case law, there's appellate review on this. This has been argued many times. I cite case law. I don't pull this out of my rear.
I understand that.
So, you can't, there's, it's binding law, right? You know, if you could persuade me, that'd be beautiful, but you're not, you're going against case law.
I don't need to. I'm just saying, look, sir, there are great lawyers and there are great clients, and sometimes just the two don't line up. And I don't want you to be, I don't want it doesn't need to be like there will be people who may see it like you do.
Like the judges that have ruled on the case law?
You should have an attorney who sees it the way you do.
I wouldn't need to. There's case law on this.
Exactly. Who could see it the way you do.
The judges, the appellate judges, they've ruled on this, what I'm talking about. I'm talking about what the judges have said. I'm not pulling this out of my rear is what I'm telling you.
Yeah. I get it.
So I've cited case law. I've cited the doctrine. Your position is unconstitutional.
My position?
Yes, because we have doctrine on this. There's the true threats doctrine.
Sir, my position is just that we disagree. That's all.
Well, to disagree with case law is unconstitutional.
It's in fact constitutional. It's my First Amendment right to disagree with that. And you could disagree with that. You could say, I don't think this lawyer knows.
First Amendment right, one thing, but going against the due process is another.
Okay. All right, sir. I'm just about getting home. I'm gonna wish you the best of luck.
I don't need your sarcasm.
I'm not being sarcastic. I'm literally right about my house. I'm going to go home and see my family. Is that all right?
You don't need to ask me that. Okay, have a good day.